deductibility is still a major factor, and as well as some perhaps lesser apparent benefits, eligibility for certain types of grants. In Virginia, the ability to conduct charitable gaming, bingo raffles and things like that. Certain statutory protections for the people who are involved with the charity so that they are not personally liable because of actions that they take in their capacity as officers or directors. And then just what I've called on the slide the halo effect, the idea that being tax exempt bestows on an organization perhaps some additional credibility for whatever positions it may take on various issues. But it's not all advantages. First of all, there are restrictions on activities that a charity can conduct. The code is very specific: charitable, educational, religious, scientific, literary, testing for public safety, etc. Those types of activities, the code says, have to be the exclusive activities. As you will learn as we get into tax speak here, words don't have their common meanings when you're talking about Internal Revenue Code concepts. So the regulations say exclusively doesn't mean exclusively. Exclusively means primarily. So there is still some room for some regular income-producing activities that aren't inherently charitable. But there again, one of the things that we have to watch as we go along is when does that become too much a part of the organization's overall activities for it to continue to qualify for tax exemption. Charities also and other types of exempt organizations also have to file regular, detailed public reports of their income and expenditures and summaries of their activities. They also have some financing options foreclosed. They can't just go out and issue stock, for example, if they need to raise money. And there's also, despite the presence of charities in pretty much all aspects of our society, a widespread public misunderstanding of what it means to be a charity or how charities ought to act. For example, there are a lot of people out there who think that charities shouldn't ever charge for their services, or that they shouldn't pay reasonable compensation for services that their employees provide. Now, one of the things that we need to focus on right away is that what I'm calling charities, or more precisely, tax-exempt organizations, is not a single category. You know, there are in the code more than 30 different categories of tax-exempt organizations. Now, the largest single group are the 501c3s, the so-called charities, but there are also 501c4 social welfare organizations that have gotten a lot of press recently because of the controversy over the IRS handling of their applications. There are C5s that are labor and agricultural organizations, trade associations, professional leagues under C6, social clubs under C7, goes all the way up to 29, and then there's some other subcategories there. For the rest of the topic, though, we're going to assume that everybody you will be dealing with is a 501c3. So the rules that we're going to go over are the 501c3 rules that apply to charities. Now, in determining whether an organization qualifies for 501c3 status or not, the IRS applies two tests: an organizational test and an operational test. The organizational test is purely documentary. Do the documents under which the entity is organized restrict its activities sufficiently so that there's a guarantee that it will be operating for permissible, tax-exempt, call them charitable, purposes? There are 5 items that need to be in those documents. Generally, what you're talking about is articles of incorporation. You know, for a non-stock corporation, if you have a trust agreement, then you're dealing with a trust instead. Same general principles. The organizational document has to limit the purposes and activities to those that are permissible under 501c3, and you can name particular purposes or activities. Operate a hospital, operate an orphanage, whatever. Or you can have organizational documents that simply say this entity will be operated and organized for 501c3 purposes, for charitable purposes within the meaning of Section 501c3 of the Internal Revenue Code. But there has to be that limitation. There also has to be a prohibition against private inurement, allowing any of the net income of the organization to inure to the benefit of a private shareholder, as the code phrases it. There has to be a limit on legislative activity. Charities are not, or most charities are not prohibited from lobbying, but lobbying can't be a substantial part of their activities. And we'll talk a little bit about what that means going forward. There is a complete prohibition currently against intervening in a political campaign on behalf of or in opposition to a candidate for public office. And that is at any level, federal, state, local, any type of public office. It applies also to actions of the public in a referendum, something like that. And finally, the dissolution clause of the governing documents has to provide that any net assets remaining on dissolution will be distributed to another charity or otherwise used for charitable purposes. So nothing can revert to the founders or the owners or the current members. It has to be clear that the assets are dedicated to charitable purposes. Now, one thing this means is that the form that is on the State Corporation Commission website is insufficient to form a charity. You can form a valid Virginia non-stock corporation just by filling in the blanks on the form that's on the Corporation Commission website, but because it doesn't contain any of these 5 limitations or restrictions, if you send that and your certificate of incorporation to the IRS, they'll just laugh and send it back, say do it over. Now, you do have to involve the IRS initially, and I'm assuming that all of the organizations you will be dealing with in the General Counsel program will be past this step. But again, you need to understand how it works. You know, in many aspects of life, the duck rule is the applicable rule. If it looks, walks, quacks, and lays eggs like a duck, it's a duck. That's all you need to know. The IRS does not adhere to the duck rule. Even if you look, walk, quack, lay eggs like a duck, you still have to go to the IRS to get a certificate attesting to your duckhood. And the way you do that is by filing an exemption application with the IRS. Now, nearly all organizations have had to file to get their exemption recognized in the first place. That is, nearly all 501c3s. Generally, they file within 27 months of being incorporated or formed, because if you file within that time, then any letter that you get confirming your exempt status is retroactive to the date of incorporation. If you wait more than 27 months to file, then it's effective only from the date you file. Now, as I said, there are a few exceptions. Churches, conventions and associations of churches and other religious entities don't have to file because of church-state separation considerations. In addition, there are a few sort of de minimis rules that say that very small organizations that have budgets of less than $5,000 a year don't have to file. And there is also a procedure for a parent that has a number of affiliates or subsidiaries to file for a group exemption that covers the parent, all the current affiliates, and any future affiliate that is added to the group with the same general structure. So you may find in a few instances that you're dealing with an organization that doesn't have its own separate determination letter, but 99% of the time, the organizations that you would be dealing with under the General Counsel program would have a separate determination letter from the IRS. Now, in the last 2 years, well, let me back up a little bit. After Katrina, the IRS started to develop a very serious backlog of exemption applications, and at one point it was taking at least 18 months for an exemption application to be processed, which was just unacceptable totally, because you had a situation where you were doing everything right, but you couldn't prove to potential donors that their contributions would be deductible because you didn't yet have that letter from the IRS. So the IRS set about trying to find ways to reduce the backlog. And what they did was basically to give up on small organizations. They came out with what's called a Form 1023-EZ. The 1023 is the regular application that the charities file. A 1023-EZ, like the 1040-EZ income tax return, is a shorter, simpler version that's made for simpler situations. So if you have a charity that anticipates that it's not going to have a budget of more than $50,000 a year, if it were applying new now, it would be able, in many cases, to file the 1023-EZ, which is basically just a claim for tax-exempt status. Unlike the 1023 itself, the 1023-EZ doesn't require the organization even to send in a copy of its articles and bylaws. It doesn't require any budget information. It doesn't require any information about what the organization is going to do other than a 3-digit classification code from an IRS list of possible activities. So there is now that procedure, and you may in fact run into an organization that has filed an EZ. They'll get the same determination letter, in effect, that a larger or older organization would have gotten, but with that simpler procedure. Now, one important exception when you're thinking about planning purposes is single-member LLCs. Normally, any new organization, with a couple of exceptions that I mentioned there, has to file an exemption application. But if you have a limited liability company whose sole member is an already recognized charity, then unless that entity elects to be separately classified, it's going to be tax exempt automatically and treated as if it were simply part of its sole member. So all of its income and all of its expenditures show up on the annual information return of the sole member. Gifts to it are treated as gifts to the sole member and deductible to the extent they would be if made to the member. So if you are trying to come up with a vehicle for a new activity for an existing charity, for example, a single-member LLC is a very streamlined way to make that happen without having to go through the time and expense and delay of a separate IRS exemption application for that new entity. Now, only 501c3s and a couple of other of the higher classifications numbers are required by the code to file applications for tax-exempt status. The duck rule applies to the others. So a 501c5 agricultural association, labor association, a 501c6 trade or professional association, like the Medical Society, the CPA Society, the Bar Association. All of those, in theory, are exempt just by how they're structured and what they do without needing an IRS letter. As a practical matter, that doesn't work in the real world, though, because even though they're not required to file, what happens is first year is completed, they prepare an information return, which all exempt organizations have to file. We'll talk about that in a minute. They send it into the IRS and they get a response from the great computer that says, we have no record of you as a tax-exempt organization. Please either file a corporate tax return or an exemption application. So at that point, then they have to file, for practical reasons, an exemption application, even though the code says they don't have to. But they file on a Form 1024, which is a a simpler form than the 1023 that charities have to go by. Now, when you file an exemption application, you are asking the IRS two questions, and this is important because this classification sticks with your charity, and so even if you're looking at a charity that has been in existence for 10 years, 20 years, you still need to know the answer to both of these questions. The first question is, of course, is the organization eligible for 501c3 status? Now, if the answer to that is yes, then the second question comes into play, and that is, what kind of 501c3 is it? Now, that has gotten a lot more complicated in the last few years than it used to be. You know, back before 1969, a charity was a charity was a charity. You either were one or you weren't one, and all charities were created equal. But in the mid to late 60s, Congress started hearing a lot of anecdotal evidence about abuses by so-called charities that were collecting money on a tax-preferred basis and then using it to advance the private political or business or social agendas of their donors rather than to do anything that was truly charitable in the normal sense of that word. So Congress heard a lot of anecdotal evidence about abuse, and it was an application of the old saying that in Washington, the plural of anecdote is not data, it's legislation. So what came out of those hearings was the 1969 Tax Act that divided the universe of charities into more favored and less favored categories. The more favored ones they called public charities. Those were the ones that went to the public on a regular basis for funding, and therefore Congress felt that there wasn't much chance of abuse there because if they weren't doing something charitable, the public wouldn't fund them. On the other end of the spectrum was this new category called private foundations. Private foundations, in general, are organizations that get their funding either in a lump sum from one source, like a contribution from an estate, and then don't have to go back to the public on a regular basis, but instead can live off their endowment and earnings, such things. Or organizations that go back to the same group of donors year after year after year, maybe the same company, the same family, the same small group, so that concern that Congress had about their being unduly influenced by their donors was still there. So they said, we are going to more heavily regulate these private foundations just to be sure that we don't have abuses in the charitable area, or to try to cut down on them. But now, in typical congressional fashion, the remedy that they concocted was perhaps overbroad. And being the suspicious body that they are, they assumed that all charities were private foundations. So a charity has to prove that it is not a private foundation. There are three ways that you can do that. There are certain types of activities that Congress just said, we're not concerned about those. Those are so directed to and involved with the public that we're just not concerned about abuse. So schools, hospitals, churches, those types of organizations are automatically public charities. Then there are some other organizations that are controlled by existing public charities. And if the public charity can control them through appointment of the board, for example, again, Congress wasn't concerned about there being too much private influence. And the third category is entities that get their support on a regular basis from the general public. And that could be either in the form of public contributions, or it could be in the form of payments for services, whether hospitals are automatically exempt, but if they weren't, they probably would fall into this category because the fees that patients pay to the hospitals would be considered public support, and so they would count toward the good in that situation. Now, for those publicly supported organizations, you don't just look at a year at a time, because there could be, particularly for fundraising organizations, there could be up years and down years. And so Congress didn't want to penalize an organization or cause it to fall into private foundation status just by having a bad fundraising year. So they look at it in 5-year snapshots. It's 5-year moving average. So you start out with a determination letter saying you are a 501c3 and we assume that you are going to be a non-private foundation, a public charity, for the first 5 years. And then at the end of the 5 years, you look at years 1 through 5 to make sure that you did actually get enough public support. The next year, you repeat the process, but looking at years 2 through 6. The next year, look at years 3 through 7. So you have to maintain over that 5-year pattern of enough public support. Now, why does it make a difference? It makes a difference because, as I mentioned earlier, Congress decided to make it harder for private foundations, to encourage people to be or to form public charities. Private foundations pay a small excise tax on their net investment income. Now, it's not taxed at a regular corporate rate. It's only 1 or 2%, but still they do pay that excise tax that public charities don't have to pay. Private foundations also are required to distribute at least 5% of their net asset value each year. So they can't just sit on their money and hoard it. There are self-dealing prohibitions that say that there are certain transactions that a private foundation simply can't engage in with an officer, a director, or substantial contributor, somebody who is a member of the family of one of those people, or a business in which those types of disqualified persons have substantial interests. And then there are also limits on how much of an interest in any business a private foundation can own. There are restrictions on scholarships. Private foundations can't award scholarships, but they have to get their procedures approved in advance by the Internal Revenue Service. Private foundations are effectively prohibited from lobbying. We always said that charities in general can lobby as long as it's not a substantial part of their activities, but private foundations are much more restricted in their lobbying. Now, that's from the organizational side. Now, from the donor side, the tax benefits of making contributions to private foundations are lower than they are if the corresponding contribution was made to a public charity. And private foundations, because of the rules that govern grants to them, may not be able to raise money from certain other sources like other private foundations. So there's a whole series of rules in the code that are designed to discourage people from forming private foundations. At the same time, private foundations are still exempt organizations. It's still 501c3s. Their income is mostly exempt from tax, and the contributions within the prescribed limits are still deductible. So better to be a private foundation than not to be exempt at all. Now, there's a lot of misunderstanding about what it means to be a private foundation or how they operate. But there are certain rules that apply to all types of exempt organizations. And we're going to have the last training session, one that has been postponed for a week, is going to focus on commercial activities and those aspects of charity status. But the thing you need to know for the purposes of this session is how far a tax exemption extends. whether the entity is a public charity or a private foundation. And these rules are basically the same. The exemption, the letter that you get from the IRS doesn't cover every dollar of income necessarily. It covers contributions, whether they're called gifts, grants, member dues, assuming that you're not getting measurable value in return for dues, for example. All of that income is free from tax for federal purposes and, for the most part, correspondingly for state purposes in Virginia as well. Likewise, receipts from exempt activities, so the tuition that the school charges, the fees that the hospitals collect from their patients, the ticket revenue from performances of the ballet or the symphony. All of those are receipts from exempt activities, and all of those dollars are exempt as well. In addition, once you need to look at whether there are other activities that are being carried on. If they're just one-time or very sporadic activities, again, those aren't going to generate taxable income. If they are regularly carried on, then you have to look at whether the activity is substantially related to the organization's purposes. And if it's not, that's when you get to the next level of analysis, because that doesn't automatically mean that the income from it is taxable. The code contains several exceptions and exclusions that apply to income from 501c3 organizations. They carve out three types of activities that they say are just not going to be taxable. Why? Because Congress said so. Perhaps because so many charities engaged in these activities, perhaps because the ones that did already had large established operations. Haven't really looked back in the legislative history to know. But if you have an activity that is carried on, or substantially all of the activity is carried on by volunteers, that is, the income from that is not taxable, even if it's not related at all to the exempt purposes of the charity. So even if it's just a fundraising activity. Now, if it's a one-time thing, of course, you never get to this point. But if it is regularly carried on, let's say the school booster club sends people to the Diamond for every home game that the Squirrels have, and they man the concession stand and receive compensation for that. Because they are all volunteers and because this exception applies, none of that income would be taxable to the booster club. There's also an exception for sales of donated items. So nothing that the Salvation Army or Goodwill sell in their thrift stores generates taxable income, even though those sales have nothing to do with their exempt purposes. They're just to raise money to fund their exempt purposes. And finally, there's what they call a convenience exception, which is very broad, and it says that any activity that's carried on primarily for the convenience of members, students, patients, whatever the constituency of the organization is not taxable. That means, in general, income from the university bookstore is not taxable. Income from the cafeteria or the snack bar at the hospital or the gift shop at the hospital or the museum is generally not taxable. Now, the IRS has drilled down on that and has started actually going in and looking at the inventory of what is being sold, for example, in a gift shop and saying, well, okay, this is closely enough related to your purpose, that is not. So you owe tax on the revenue from that item, but not this item. And it can get incredibly complicated, but the general rule is supposed to be that anything that's carried on for the convenience of your constituents shouldn't generate taxable income. Now, even if you are down to that point in the analysis and you still have not found an exception or something to exclude the income, certain types of income are just excludable, again, because Congress said they were. Primarily ones that are more passive. So interest, dividends, annuities, rents, royalties, capital gains, things like that in general are not taxable, although there are ways that you can take yourself out of those protections if you're not careful and if you don't go all the way down to the bottom of the decision tree. Now, those are the federal rules, and again, they apply for the most part to the state income tax as well, because the starting point for determining Virginia taxable income is federal taxable income. There are also rules that we're not going to go into today relating to things like state property tax exemption, state sales and use tax exemption. Those are entirely separate from 501c3. A 501c3 designation does not automatically get an organization either property tax or sales tax exemption, although it's generally a prerequisite to either one. So one of the things that the General Counsel are going to be looking at, I assume, is how do you maintain the tax-exempt status of the organization once it's been achieved. And basically, we're looking at 7 steps here. One is just to make sure that they are using good governance practice, so that they are conforming to their organizational documents and so on. Then monitoring the private foundation status to see whether they're continuing to meet the criteria for non-private foundation status. Again, if it's a school, hospital, church, something like that, or if it's a supporting organization that is connected by a corporate link to an existing charity, then in either case, all you have to do is just make sure that that is maintained. If it's a publicly supported organization, then you've got to make sure that they're doing the math every year and looking ahead, so that if it looks as if they are not going to be raising as much public support as the code says they should, they have a chance to do some additional fundraising or make other adjustments. And we're going to talk in just a minute about what that means from a practical standpoint. You have to make sure that they have avoided private inurement, which is tax talk for allowing insiders to get disproportionate benefits. You have to make sure that they have not gone over the line, wherever that may be, into substantial lobbying. Because again, the code just says attempts to influence legislation should not be a substantial part of their activities, whatever that means. You have to be sure that they stay entirely away from campaign intervention, for or against a candidate, and that can be direct or indirect, so there's danger there. And you have to be sure that they are making all the filings that they're supposed to be making. Now let's look a little bit more closely at each one of those categories. What are you going to be looking at in order to determine whether their governance is proper? And again, you may not be asked to do all of this, but these are just some issues that could come up depending on the type of organization you get matched with and what its particular needs may be. We start out with the articles and bylaws, of course, but we have that peculiar provision in the Non-Stock Corporation Act, 13.1-852.1, that authorizes member or director agreements. And a member or director agreement is simply an agreement among the members or directors of a corporation that says, we don't like the state rule, so we're going to make this rule and operate by it instead. So you can ignore almost anything in the code as long as what you're doing is not against public policy, as long as you document it properly in a member or director agreement. But once you have one of those in place, there are very specific rules about following them, about how long they can be in effect, about what you have to do in order to change them if a change becomes appropriate. So be aware of the possibility that there may be member or director agreements that allow or require your particular charity to do something that state law otherwise wouldn't allow or require. Then there's of course, state law itself. You've got the Non-Stock Corporation Act, if you're dealing with a corporation, as most often you will be. Maybe the Limited Liability Company Act, if they have an LLC affiliate. You have the Uniform Principal and Income Act, the Uniform Prudent Investor Act, any number of charities, including our old friend UPMIFA, the Uniform Prudent Management of Institutional Funds Act, which provides a fairly good roadmap for boards to follow in making decisions about how to invest their endowments and other funds and what expenditures to make from them. And another thing that UPMIFA does is to give you a roadmap for how to either remove or modify restrictions on certain funds that have become outdated for one reason or another. So there's some important tools in state law that you need to be aware of as well. Then there are the organization's policies. Some don't have any. They've got articles and bylaws and that's it. Others have policy manuals that thick. The IRS information return that a charity files asks some questions about, and so does the exemption application, asks some questions about what policies, and specifically asks, does the charity have a conflict of interest policy? Does it have a whistleblower policy? Does it have a document retention policy? There's a little bit of push polling going on, to use a term from our current election season. The IRS has no authority at all in that area. Those are state law issues. But the IRS nevertheless has some definite ideas about what a well-governed charity ought to look and act like. And so they're asking those questions in the hope that they'll push you toward a yes answer and push you toward actually adopting those types of policies for your charity. But just be aware that for tax purposes, at least, a no answer doesn't cause you any problem. But it is a good idea to suggest that charities have policies that are appropriate for their situations. A gift acceptance policy is a really good example, because it lets you set out some guidelines for the fundraisers and for the board before you get into all the personalities and politics involved when one of your major supporters comes in with a gift that you absolutely don't want, but you're trying to figure out how to say no. The one thing I will say, if you're going to have a policy, follow it. The only thing worse than not having a policy on a particular matter is having one that you don't follow. But that may be one thing that you're asked about is, what policies do we need and where do we get them? And that takes a good bit more work than some people think, because you can go to the internet and find any number of gift acceptance policies. But if you just find one from some very well-known national charity and just slap your organization's name on it, chances are you've done them a real disservice, because they may not have all the same considerations. They may not have the ability to accept some types of gifts that the policies say they will. So if you're helping them develop policies, it's going to take some thought to figure out what is a proper policy for them and get it implemented. Now, donors also may, from time to time, impose restrictions on gifts that they give, whether it is in the form of an endowment or limited use of some particular asset, whatever it may be. So be aware of those as well, and make sure that the charity has a system for keeping track of those and remembering those, so that those don't get lost in the midst of time. And finally, in some cases, you'll be looking at actual court orders that arose either from the formation of the organization or from some significant funding that it received as a successor to another organization or as a beneficiary of an estate or trust or something like that. So there are any number of sources that you may have to look at when you're thinking about conformity to proper governing practices. Now, we talked a little bit about monitoring the non-private foundation criteria. And again, if you have a supporting organization, then the primary thing you need to do is just make sure that that corporate link that ties them to an already established charity is still there so that they can retain their non-private foundation status. This area got a whole lot more complicated, though, after, about 10 years ago, after the passage of the 2006 Tax Reform Act, because beforehand, as I said, there were basically three ways that you could be a public charity, either being a school, hospital, church, or one of those per se categories, being publicly supported, or being a supporting organization that was linked corporately to an existing recognized charity. And if you were in that supporting organization category, it didn't matter how. It could be a so-called type 1 supporting organization where the charity directly controlled the organization that was supporting it. So a charity, museum, school, hospital, church, whatever, sets up an endowment fund and appoints all of the board members of the endowment fund. Now, that's direct control. That direct link is a type 1 supporting organization. And so that was fine. It was also fine with a so-called type 2 relationship where the charity and the supporting organization were sort of like brother-sister corporations, both controlled by a common parent. Both of those involve direct control. The third category, the type 3 supporting organization, was just a looser link. It could be an organization that was set up to support the museum, but that had an independent board that the museum didn't appoint, or the museum didn't appoint a majority of the board. That so-called, that sort of dotted line connection was a type 3. And again, it didn't matter whether you're type 1, type 2, or type 3, as long as you were a supporting organization until the 2006 legislation that became effective in 2007. That made substantial distinctions between types 1, type 2, and type 3, depending on, related to what types of contributions they could solicit and accept. And basically, this is a gross oversimplification, but basically only the ones that were directly controlled by the charity they supported had a full range of fundraising ability from there on. It's gotten even more complicated because the type 3s have been divided into two categories, and those have additional distribution requirements. So if you have any organization that's classified as a supporting organization, it's really important for you to drill down and see what type of supporting organization it is so that you can know what they have to do to maintain that status and what that status means for their ability to raise funds. Can they accept rollover contributions from an individual donor's IRA? Can they accept contributions from a donor-advised fund? Things of that type. And again, all this is a function of tax status and way more complication than we have time to do anything but mention in this session today. Now, if you're a publicly supported organization, then there are two ways that you can satisfy that test. And again, you do it on a 5-year basis, 5-year snapshot. During that 5 years, you generally have to show either that you received at least a third of your contribution of your revenue from public contributions, or that you've received a third from public contributions and receipts from exempt activities, and not more than a third from investments in unrelated trade or businesses. Now, it's almost as unintelligible as I just made it sound there, but not quite so much. Basically, there are two tests. If you exist primarily, or if you're supported primarily through public contributions, not selling goods or services, but just going out and soliciting donations, as long as you get at least a third of your revenue during that 5-year average from those sources, then you're considered publicly supported and are a non-private foundation, a public charity. You can actually go as low as 10% if you also meet a facts and circumstances test that shows that you're trying to encourage public support and public involvement in your activities. Now, one of the problems here is that even within these sections of the code, the same word means different things. Because if you're looking at that 1/3 of support test, support means only gifts, grants, contributions, membership fees, investment income, and income from unrelated trades or businesses. It does not include any income from sale of goods or services that's part of your exempt activities. That may sound illogical, but Congress had a reason for it, actually. When you're applying the other tests, at least a third public and no more than 1/3 investment income and unrelated business income, that does include, in the definition of support, receipts from exempt activities. So there are 40 or 50 pages of regulations on this, and the best thing to do is just to make sure that either some internal financial person in the organization or their return preparers are doing the math every year and projecting at least a year ahead, so that if they know they're getting close to one of the thresholds, they can go out and do some more fundraising, invest in a form that doesn't throw off as much endowment income, or do something to make sure that at the end of the current 5-year period they can maintain their public charity status. Now, as we said earlier, 501c3s are allowed to engage in some income-producing activities that aren't substantially related to their exempt purposes. But the question is how much, because it just says that that those activities can't be a substantial part of the organization's overall purposes. No definition of substantiality, no definition of primarily for exempt purposes. This whole area you will find is sort of like the analyses that went on 20 or 30 years ago when the Supreme Court was trying to figure out what pornography was. They never could define it, but they knew it when they saw it, right? I mean, that was basically what it came down to. And many of the concepts in this operate on that pornography standard. You sort of know them when you see them, or you get a feel for them, but there are no bright lines. And that's what makes it so treacherous for organizations, because they can very easily step over a line without even knowing that it was there, as opposed to out there someplace. So the first thing is to be sure that the activities are properly classified. Is there a reasonable argument that they are substantially related to the organization's exempt purposes? If not, do they fall within one of those exceptions that I mentioned earlier for volunteer activities, for sale of donated goods, or for the convenience of constituents? If not, then you have to worry about whether that has become a primary activity. And there's no way to measure, in the sense that the IRS hasn't told us, whether it's primary in terms of gross revenue, net revenue, staff time involved, staff and volunteer time, or some combination of those and perhaps other factors. So if you think, just based on your, I know it when I see it type of intuition, that a charity is getting close to the line where where it would be considered to be primarily involved in some unrelated activity, consider forming a taxable subsidiary. The charity can own all the stock in a for-profit business, and as long as the business is conducted in a separate entity, you can account for and pay tax on that revenue without jeopardizing the tax exemption of the parent charity or the tax exemption of any revenue that it brings in the form of contributions or receipts from its exempt activities. So there may be situations where one of your recommendations would be, look, you're getting close enough to the no man's land here that you really ought to consider putting this activity in an unrelated in a subsidiary, paying tax on it at just regular corporate rates, and then funneling the net income upstream as needed to the parent to support its exempt activities.
Can you do that with an LLC?
Pardon me?
Can the affiliate be an LLC?
The affiliate can be an LLC as long as the LLC has elected to be taxed separately. Because if it's just a single member LLC, then for tax purposes you haven't gotten it out of the charity. Because remember, all the revenue and expenses of a single member LLC normally would be shown on the charity's return. Now, two other areas that may require particular attention: sponsorship arrangements and co-ventures. If you had, there was a sort of a shudder through the exempt organizations community several years ago when the IRS came to the Cotton Bowl organization. The Cotton Bowl organization is a 501c3. And it said to them, that sponsorship agreement you just signed with Mobil that turned this into the Mobil Cotton Bowl and plastered Mobil's logo all over the field, all over the players, and had certain other benefits from Mobil. We think that was not a contribution. We think that was a sale of advertising, and oh, by the way, you owe corporate tax on that entire amount. Well, that was a shock to them and to a number of other organizations, not just bowl games, but museums that have sponsors for big exhibits and things of that type. They went to Congress. Congress rolled back that position partially, but you still have to determine whether a payment in that type of situation is a contribution or whether there are so many benefits going back to the sponsor that it should be considered a taxable sale of advertising. And there's some very specific rules there relating, among other things, to what type of acknowledgement you can make. And the distinction there is between just an acknowledgement, thank you for your donation, and something that is a qualitative or quantitative comparison or an inducement to purchase or endorsement. Those are terms from the regulations. Basically, if you say this program was brought to you by a generous grant from Mobil Corporation, that's fine. That's an acknowledgement. If you say brought to you by Mobil Corporation, the maker of the best gasoline, petroleum products in the world, that's an endorsement or inducement to purchase, and you just turn Mobil's contribution or a substantial part of it into taxable income for the charity. Now, it makes no difference to Mobil in all likelihood, because if Mobil can't deduct it as a charitable contribution, it can deduct it as advertising or business expense. So, not their problem, but it can be a major problem for a charity that thinks it's going to have 100 cents on the dollar to apply to its operations and find that it only has, say, 60 cents after taxes. The same way with co-ventures. If a 501c3 gets into any sort of partnership or joint venture with a for-profit investor, whether an individual or a company, that sets off all sorts of alarm bells at the IRS, because the IRS used to say that any sharing of profits between a charity and a for-profit investor was private inurement, which is against 501c3, so it automatically disqualified the charity from 501c3 status. They lost a couple of high-profile court cases now 30 years ago on that, so they retreated from that absolute prohibition and said, well, all right, the courts say we have to let you do this, but you can do it only if the purpose of the venture is not just to make money, but rather to do something that contributes substantially to your exempt purposes. And if the structure of the venture is such that if there is ever a conflict between the profit motive and the charitable purposes of the venture, the charitable purposes will predominate. Now, how do you translate that into real-world business dealings? With great difficulty. That's the reason that you have to tread very carefully if you're thinking about any sort of joint venture, because you could be gambling the organization's tax-exempt status. Now, private inurement, again, it's the pornography standard. We know it when we see it. In fact, the IRS can't even define it very carefully, because there is private inurement and there is private benefit. Inurement is the classic insider benefit, a disproportionate benefit of some type to an officer, director, a substantial contributor, member of their family, business interest, etc. That is grounds for revocation. But the IRS also says that even if the benefit flows to somebody who is not an insider, if it is so disproportionate to the charitable benefit flowing from the activity that it just looks like an overweighting, that there will be there's danger to exemption. Now, what did that mean? Nobody knew, and for decades, charities lived in fear of violating the inurement prohibition. Finally, in now 20-some, probably closer to 30 years ago, the IRS said, well, all right, we will give you some guidelines. And they put in what they call the intermediate sanction, so that if there was some excessive benefit provided to an insider, instead of losing its exemption, the organization would report that, and there would be penalties not on the organization, but rather on the person who had received the excess benefit. So, those types of complaints led to Section 4958 of the Internal Revenue Code, which applies to any transaction between a charity and an insider, an officer, director, substantial contributor, family member, etc., or anybody who has been in that status in the preceding 5 years before the transaction. In that case, there's a provision in the regulations that allows a charity to create a rebuttable presumption that whatever the transaction is, whether it's payment of compensation, whether it's a purchase or sale of an asset, whatever it may be, that is reasonable. And in order to do that, basically what you have to do is show three things. That the transaction was approved by a disinterested group of deciders, that is, the members of the board of directors who did not have a financial interest in that transaction, for example. Number two, that in considering the transaction, they also considered appropriate data as to comparability, whether that's compensation surveys, whether it's other offers for the individual's services, whether it's an appraisal, if it's a purchase or sale transaction, anything like that. And third, that they document that whole process, the decision-making process and the decision made in some sort of contemporaneous written record. And again, if the IRS were to come in and show at some point later on that there had been an excess benefit, that the compensation paid to the CEO was unreasonable based on the amount of work actually done, the penalty would not be loss of exemption for the organization. Instead, the penalty would be on the CEO. It would be a two-pronged penalty. You have to pay a 25% excise tax on the excess benefit. So if the salary should have been $400,000 and it was $500,000, he would owe a tax of 25% on that $100,000 of excess benefit, and would also be required to refund the full $100,000 to the charity with interest. If he didn't do that promptly, the IRS gets a little testy, and in that case, there is a second excise tax equal to 200% of the amount involved. So $25,000 first level tax, $100,000 refund plus interest. If the 100 isn't refunded, 200 in additional tax, plus a continuing obligation to refund the 100 plus interest. So they mean it. But again, the focus is right now because the penalty is on the person who received the benefit and not necessarily on the organization, unless it shows that there was basically collusion and the board approved the transaction knowing that it did confer an excess benefit. Now, the lobbying prohibition and the campaign intervention prohibition are widely misunderstood because 501c3s, unless they're private foundations, can lobby. It just can't be a substantial part of their activities. And the regulations that have evolved over the years say that there are a lot of things that you or I in common parlance would speak of as lobbying that don't count for this purpose. So if a charity is publishing material on broad social issues, if it is publishing the result of a nonpartisan study or research, if it is invited by a legislative committee to present testimony on a particular issue, or if the issue involved relates to the very existence or tax-exempt status of the organization, then that doesn't count as lobbying at all. You can do as much of that as you want to. Beyond that is where we got back into the pornography type standard, what was substantial. And again, charities complained for years about the lack of certainty. So finally, Congress came up with Section 501H. And this may be important for your organizations as well. 501H puts numbers and percentages to the concept of substantiality and sets a ceiling on how much a charity can spend in a given year on legislative activities that aren't within those exclusions in the second bullet as a percentage of its budget. So can spend 20% of the first $100,000, 15% of the second 100, 10% of the third 100, 5% of the fourth, and so on, up to a maximum of $1 million a year on lobbying. Now, this wouldn't be any fun if there weren't exceptions and exclusions and so on. So one of the things that Congress did was say, we're going to, again, distinguish between types of lobbying. Grassroots lobbying, attempts to influence the public, can't account for more than 1/4 of that total. The rest has to be spent, if it's spent at all, that can only be spent on direct lobbying, direct contacts with legislators or their staffs. Now, why? My cynical answer is that Congress said, well, if people are going to spend money on lobbying, we want it spent on us rather than on public support. But that, I don't know. That's just my cynical answer.
Does it matter if the activity does not constitute lobbying under state lobbying?
No, the state lobbying rules are entirely different, and so you do have to comply with those as well. But the fact that it is or is not lobbying doesn't say anything at all, for state purposes, doesn't say anything at all about its federal classification.
You're lobbying a regulatory agency in Virginia to not adopt or adopt some new regulation. That doesn't constitute lobbying under Virginia law.
Well, I'm glad you brought that point up, because that also doesn't count as lobbying for federal purposes, because remember, the federal definition is attempts to influence legislation. So that's the legislative branch. In general, contacts with the executive branch don't count against you at all. So regardless of the position you took on the legislation, if the legislation is passed and it's over in some agency for development of regulations, you can express as much of a position on the regulations as often as you want without it counting as lobbying. Because again, that's not the legislative process, that's the executive branch. Now, that the 501H not only gives you numbers to judge by, but much like those intermediate sanctions we talked about for compensation and inurement, it imposes a penalty that is not loss of exemption. If you go over the permissible amount for a year, all that happens is that you pay an excise tax on that extra amount. And only if you consistently exceed the thresholds by 50% or more do you endanger your exempt status. So many organizations that do some lobbying and that are concerned about the possible application of that rule may want to consider a 501H election. It's something that you can do on a year-by-year basis. Once you elect it, it applies to that year and all future years until you revoke the election, so that you can elect, if you're concerned about it, to have your lobbying judged as a percentage of your expenditures rather than by some other substantiality standard. Now, one of the newer issues, in one sense, is annual filings, because it used to be that small organizations, with $25,000 a year or less in gross receipts, didn't have to file anything. Everybody else, the larger organizations, filed Form 990, an annual information return, or in some cases a 990EZ, abbreviated version of the same form. The rules changed, though, starting in 2007, and everybody, except for churches and ones that are exempted for other grounds, needs to file something, either a 990, a 990EZ, or for the smallest organizations, what's called a 990N, which is just a "we're still here" notice. Doesn't require any financial information, just updating contact information and a notice that the charity is still in operation. If you don't file something, whatever the proper form is, for 3 successive years, you automatically lose your tax exemption and have to reapply. Now, you can reapply and get it reinstated retroactively under certain circumstances, but it's a pain, it takes time, it creates uncertainty in the meantime while you're in that gap period. And there's some cost involved as well. So you need to be sure that every organization, unless it's a church or otherwise exempted, files some form of 990 every year. If it has unrelated business taxable income of more than $1,000, then it's also required to file Form 990T, which is T for taxable, to show that taxable income. Now, it's important to remember that an organization that has unrelated business income is not any worse off than if it were just a regular taxable business. That is, it gets the same deductions in calculating the amount of its taxable income that a for-profit business would get. But it does have to file a 990T. And while there's no Virginia counterpart to the 990 information return, there is a Virginia counterpart, the Virginia Form 500 corporate tax return that has to be filed to pay Virginia state income tax on that unrelated business income. Also need to be sure that they file their SCC annual reports and pay the registration fee after or each year in order to avoid being administratively dissolved. If they're soliciting contributions, they need to have registered, in most cases, with the Consumer Affairs Office under the Solicitation of Contribution Act. And if they haven't gotten an exemption initially, then they have to renew that registration each year and pay a registration fee that's based on the amount that they have raised from the public in contributions during the preceding year. And if you have an organization that is large enough to be issuing charitable gift annuities to its donors, then there are some specific requirements there for the annual filings relating to gift annuities. Now, a lot of those things and some other documents have to be available for public inspection as well. So you need to be sure that the charity has available for public inspection its initial exemption application, the Form 1023 that it filed, and any related correspondence, the determination letter that it got as a result of filing the 1023, and any correspondence updating or changing its tax status. Its three most recent Forms 990 information returns. Now, 1023 and the determination letter always have to be available for public inspection. The 990s and the 990T have to be available only for 3 years after their filing date. But those have to be available at the principal office during regular business hours for anybody who wants to come in and see them or get a copy. You can't ask why, or you can't deny access on any basis. Any member of the public who calls in or writes in has to be able to get copies. And there are small, but nevertheless penalties on an organization that fails to make all those documents available. So that's also something to keep in mind. And that when you say making the documents available, that means the 990 as it is filed, including every little detail, except public charities can mask their contributor identity information. There's a Schedule B that lists contributors who have given $5,000 or more during the year. That contributor list does not have to be made public, but everything else on the return does. And if you're a private foundation, even the contributor list has to be made public.
Is posting on a website sufficient, or do you have to?
Posting on a website is generally sufficient, yes. Now, this is incredibly dense stuff, and a lot of people just don't accept it. What they say basically is, we're charities, we're doing good things, don't bother us with the details. So, you may end up in situations like this where the CEO complains about paying too much taxes and says, bring me a physicist and a tax attorney. He tells them, I want to incorporate in another dimension, make it happen. The physicist says somewhere in the multiverse, it's already done. CEO, I like you. The lawyer guy is fired. You may get into situations like that, but in order to fulfill the role of the general counsel in the sense of issue spotting, it's important that you know that these issues are there and at least alert them to it. What they decide to do about them is, of course, ultimately their responsibility, but at the same time, you will have alerted them. Now, these are but a few of the rules, of course. Those of you who were here for the earlier training sessions know that there are separate rules on several other important topics. Contribution deductibility. We spent a good bit of time on that in one of the earlier sessions. And the documentation that is required, because as you'll recall from the earlier session, the IRS has become very aggressive and been very successful in attacking deductions based solely on deficiencies in the documentation. When there was no dispute over the value of the gift, whether the gift was made or what value it was, but defeating deductions solely because the documentation wasn't done right. We haven't even talked about planned giving vehicles. There are only 9 ways in the code that you can make a contribution to a charity of less than your entire ownership interest in property and get a deduction. So it's important to know, for the charity to know what those are, and for the donors to know what they are, to be sure that the tax benefits that should be there do actually materialize. We talked a little bit about the sponsorship rules. There are also separate rules for things, for fundraising events like galas, auctions, raffles, and different consequences for deductibility depending on whether you were the person who gave the item for the charity auction or the person who bought it at the charity auction. Again, a whole set of separate rules on those. And I mentioned earlier our friend UPMIFA with endowments and restricted funds and the guidelines that it contains for dealing with those types of assets. So that, I'm sure, is more than you ever thought you wanted or needed to know about the tax aspects of all this. Again, we have just scratched the surface, but I hope it will give you a good framework that you can use as you go out to meet these organizations, deal with them, or as you just, in your practices or in your private life, encounter charities and they say to you, we've got a legal question here. You're a lawyer. What about this? So I hope it's been helpful. If you have questions or comments, I'll be glad to stay around. I would imagine the reception is about to start out in the hall.